On January the 14th, 1992, Wuornos went to trial for the murder of Richard Charles Mallory. In Florida, a defendant convicted of murder can be punished by death if the murder is found to have been committed under certain circumstances listed in the Florida Penal Code, such as the murder of a police officer or firefighter, that the defendant murdered 2 or more victims, that the defendant committed a murder for hire, or that the murder was intentionally committed in the course of a kidnapping, burglary, robbery, aggravated rape, or other statutorily specified felony. The subclass of murders falling into these categories is called capital murder. Wuornos was charged with the first-degree murder of Richard Mallory, armed robbery with a firearm or deadly weapon, and possession of a firearm by a convicted felon. Prosecutors argued Wuornos qualified for the death penalty based on the charge of murder committed in the course of a robbery. Capital trials are different in several ways from murder trials, in which the defendant is not eligible for the death penalty. First, jury selection in capital cases requires that prospective jurors be death qualified, questioned about their ability to consider both aggravating and mitigating evidence and to render a death sentence in an appropriate case. Only jurors who are willing to consider sentencing someone to death may be selected. After the jury is chosen, the government has the burden of proving the defendant's guilt beyond a reasonable doubt and offers evidence to convince the jury the defendant committed the offence. The defendant can offer evidence to rebut the prosecution's evidence or to establish innocence, but has no burden of proof and is presumed innocent until proven otherwise. That is very important. That will come up later in this video. Wuornos' capital trial for the murder of Richard Mallory began on January the 14th, 1992. Wuornos took the stand as the only defense witness, repeating her tale of violent rape and beating at Mallory's hands, insisting that she shot him dead in self-defense, using her pistol only after he threatened her life. Wuornos' case was tried in Volusia County, Florida. Tricia Jenkins, Chief Assistant Public Defender of the 5th Judicial Circuit, represented Wuornos at her trial. Wuornos stood trial only once, as she pleaded no contest or guilty to the subsequent murder charges. Private attorney Stephen Glazer represented her following the first trial and arranged those pleas of no contest or guilty. The district attorney at the time of Wuornos' trial was State's Attorney John Tanner. Judge Uriel Blount came out of retirement specifically to try the Wuornos case. Prosecutors based their case mainly on the videotaped confession Aileen Wuornos gave to detectives during interrogation. Although previous convictions are normally inadmissible in criminal trials, under Florida's Williams rule, the prosecution was allowed to introduce evidence related to her other crimes to show a pattern of illegal activity, thus showing motive, intent, knowledge, modus operandi, or lack of mistake. Prosecutors dismissed Wuornos' initial claims that all 7 murders were in self-defense by pointing out that Wuornos' story varied with each subsequent telling. In the earliest confession to officers, Wuornos said Mallory picked her up while she was hitchhiking, and they later went into a secluded wooded area to engage in an act of prostitution. She and Mallory then began arguing. Wuornos said she felt Mallory was going to roll her, take her money and rape her. She grabbed a bag in which she kept a gun, and the two began struggling over the bag. Wuornos prevailed, pointed the gun at Mallory and said, "You son of a bitch, I knew you were going to rape me." To which Mallory responded, "No, I wasn't. No, I wasn't." At this point, Wuornos shot Mallory at least once while he was still sitting behind the steering wheel. Mallory crawled out of the driver's side and shut the car door. Wuornos said she ran around to the front of the car and shot Mallory again, causing him to fall to the ground. While he was lying there, Wuornos shot him twice more, went through his pockets, concealed the body beneath a piece of rug, and drove off in his car. Wuornos also told law officers she had given Tyria more inconsistent versions about what had happened. In one, Wuornos told Moore she had found a dead body hidden under a scrap of rug in the woods, but in another, she confessed to the killing. In her initial taped confession, Wuornos never mentioned that Richard Mallory had raped her. During the confession, it appeared Wuornos was not focused on clearing herself so much as clearing her lover, Moore. Moore had cooperated with police to convince Wuornos that Moore was going to be prosecuted unless Wuornos fully cooperated. Many believed Wuornos appeared confident and not at all upset during her confession. She made easy conversation with her interrogators and repeatedly told her public defender to be quiet. She said, "I took a life. I'm willing to give up my life because I killed people. I deserve to die." Wuornos' attorneys engineered a plea bargain, to which Wuornos agreed, in which she would plead to 6 charges and receive 6 consecutive life terms. One state attorney, however, thought she should receive the death penalty, so on January the 14th, 1992, Wuornos went to trial for the murder of Richard Mallory. The defense argued Wuornos' statements in the videotaped confession were obtained involuntarily and in violation of her right to due process. Despite the fact that she was advised of her Miranda rights and provided with a public defender who advised her not to make any lengthy statements, law enforcement's exploitation of her relationship with Moore in obtaining the confession so impaired her mental state and level of functioning that she did not have a rational understanding of her rights and the advice of counsel. The trial court rejected this argument and denied the defense motion to suppress the videotaped confession. Moreover, the videotaped confession had already been leaked to the media, further influencing the public's perception of Wuornos. During later interviews with police, Wuornos went into detail about her self-defense claim. She explained she had offered to perform an act of prostitution with Mallory, and he drove to an isolated area where the two drank, smoked marijuana, and talked for about 5 hours. Wuornos described herself as drunk royal. About 5 a.m., Wuornos disrobed to perform the act of prostitution. She asked Mallory to remove his clothes, but he said he wanted only to unzip his pants and didn't have enough money to pay her fee. Wuornos went to retrieve her clothes, but Mallory whipped a cord around her neck, threatened to kill her like the other sluts I've done, and tied her hands to the steering wheel. According to Wuornos' later version, Mallory violently raped her vaginally and anally and took pleasure from her cries of pain. Mallory eventually untied her and told her to lie down. Believing he intended to kill her, she began to struggle. Mallory told her, "You're dead, bitch, you're dead." At this point, Wuornos found her purse and removed her gun. Mallory grabbed her hand and the two began fighting for the gun. Wuornos prevailed and shot Mallory. Mallory kept coming at her despite her warnings, so she shot him twice more. Against her attorney's wishes, Wuornos testified at trial. A defendant has a constitutional right not to testify, and the prosecution could not call her to the stand. However, once the defendant testifies, any refusal to answer questions can be held against her by the court and jury. During her testimony, she repeated her claim of self-defense. During cross-examination, she became agitated and angry. Her attorneys repeatedly advised her not to answer questions, and she invoked her Fifth Amendment right against self-incrimination 25 times. She was the only defense witness. Wuornos' defense also raised an issue that soon after her arrest, 3 detectives on the case, as well as Tyria Moore, talked to the media to sell their story. Some people suspected such deals influenced the witnesses to exaggerate their stories to more lucrative offers, but we'll go into the media frenzy a bit later. The evidence and witnesses against her were severely damaging. Dr. Arthur Botting, the medical examiner who had autopsied Mallory's body, stated that Mallory had taken between 10 and 20 agonizing minutes to die. Tyria Moore testified that Wuornos had not seemed overly upset, nervous, or drunk when she told her of killing Mallory. 12 men told of encounters with her along Florida's highway over the years. Wuornos' defense made efforts during the trial to introduce evidence that Mallory was previously convicted for attempted rape in Maryland and served a sentence in a maximum security correctional facility providing remediation to sexual offenders. Records obtained from the correctional institution showed that from 1958 to 1962, Mallory was committed for treatment and observation resulting from a criminal charge of assault with attempt to rape, and received an overall 8 years of treatment from the facility. In 1961, it was observed of Mr. Mallory that he possessed strong sociopathic trends. However, the judge refused to allow the records to be admitted in court as evidence and denied Wuornos' request for a retrial. Wuornos' claim of having killed in self-defense would have been a lot more believable had the jury known about Mallory. Now, with the jury made aware of all the other murders, self-defense seemed improbable at best. After the excerpts from her videotaped confession were played, the self-defense claim seemed ridiculous. On the tape, Wuornos appeared confident and not at all upset by the story she was telling. Tricia Jenkins, one of Wuornos' public defenders, did not want her client to testify and told her so, but Wuornos insisted on telling her story. By now, her account of Mallory's killing barely resembled the one she gave in her confession. Mallory had raped and sodomized her, she claimed, and had tortured her. On cross-examination, prosecutor John Tanner obliterated any shred of credibility she may have had. As he brought to light all her lies and inconsistencies, she became agitated and angry. When she left the stand, there was not much doubt about how her trial would end. On January the 27th, Judge Uriel Blount charged the jury. They returned with their verdict less than 2 hours later. They found Wuornos guilty of first-degree murder, and as they filed out of the courtroom, she exploded with rage, shouting, "I'm innocent. I was raped. I hope you get raped, scumbags of America." Expert witnesses and psychiatrists for the defense testified that Wuornos was mentally unstable and diagnosed her with borderline personality disorder and antisocial personality disorder. They also added that her tumultuous upbringing had stunted and ruined her. Jenkins referred to her client as a damaged, primitive child, as she pleaded with the jury to spare Wuornos' life. But jurors neither forgot nor forgave the woman they'd come to know during the trial and found her guilty on all counts, including first-degree murder and armed robbery. This outburst likely was fresh in the jurors' minds as they began the sentencing phase the next day. The penalty trial or sentencing phase was held before the same jury to determine whether she would be sentenced to death or life in prison. In most states at this penalty trial, the jury chooses between death and life imprisonment by deciding whether the case involves certain statutorily specified aggravating circumstances, facts that make the crime more serious or the defendant more deserving of death, and mitigating circumstances, facts that extenuate the crime or make the defendant less culpable, and then whether the aggravating circumstances outweigh the mitigating circumstances. The High Court ruled that only juries and not judges can sentence inmates to death. In Florida, juries make a recommendation to the trial judge who imposes the sentence. The state's expert psychologist, Dr. Bernard, testified that Eileen Wuornos suffered from both borderline personality disorder as well as antisocial personality disorder. Although he agreed with other experts that Wuornos experienced impaired capacity and mental disturbance at the time of the crime, he concluded the impairment was not substantial and the disturbance was not extreme. He also agreed there was evidence of non-statutory mitigating evidence, such as Wuornos' mental problems, alcoholism, disturbance, and genetic or environmental deficits. In response to the introduction of evidence of Wuornos' difficult childhood and upbringing, the state called 2 witnesses from her childhood: Laurie Grody, Wuornos' biological aunt and stepsister, and Barry Wuornos, her biological uncle and stepbrother. Barry Wuornos testified Wuornos' grandfather laid down rules and was someone to look up to. Although he had never seen his father beat Eileen, she sometimes was spanked, and when she was 10, the discipline became more tight. Barry testified that Eileen's biological father, who committed suicide while in prison for rape and kidnapping, was abusive and a criminal type. In the penalty phase, the defense introduced evidence about Wuornos' background. Her teenage parents separated months before she was born. Her father, Leo Pittman, moved on to serve time in Kansas and Michigan mental hospitals and later committed suicide in prison, where he was serving time for child molestation and kidnapping. Eileen's teenage mother, Diane Wuornos, described her and her older brother Keith as crying, unhappy babies. Diane's troubled parents adopted Eileen and Keith after she abandoned them. Wuornos' life with her grandparents was physically and verbally abusive. At 6, she suffered facial burns and scarring when she and Keith set fires with lighter fluid. During junior high, Wuornos began exhibiting hearing loss, vision problems, and trouble in school. Her IQ was established at 81, in the low dull normal range. An IQ at or below 70 is generally accepted as indicating mental retardation. Following the US Supreme Court's ruling in Atkins v. Virginia in 2002, the mentally retarded cannot be sentenced to death. School officials urged that Wuornos receive counselling and tried to improve her behaviour by administering a mild tranquilizer. At about 14, Wuornos was raped by her grandfather's adult friend. She waited 6 months before revealing she was pregnant, for which her grandparents blamed her. Her grandfather later sent her away and forced her to give up the child for adoption. After her grandmother died, her alcoholic grandfather threatened to kill her and her brother if they weren't removed from his house. At age 15, she became a ward of the court. She soon dropped out of school and began engaging in prostitution, as well as alcohol and drug abuse. Her brother died of cancer at 21, and her grandfather committed suicide. 3 defense psychologists concluded Wuornos suffered from borderline personality disorder at the time of her crime, resulting in extreme mental or emotional disturbance. They said her ability to conform her conduct to the law was substantially impaired, and she exhibited evidence of brain damage. One testified her consistent confessions should not be considered lying or changing stories, in a subjective sense, because of her borderline personality disorder. The defense attempted to portray her as a woman who had lived a horrible life of victimization and violence with little help from anyone, and who later lashed out at one of her victimizers. The jury recommended the death sentence by a vote of 12-0, concluding that 5 aggravating circumstances and only 1 mitigating factor were present in Wuornos' case. The 5 aggravating circumstances found were: 1. Wuornos had a previous felony conviction involving the use or threat of violence. 2. Murder was committed during the commission of a robbery. 3. Murder was committed in order to avoid arrest. 4. Murder was heinous, atrocious, or cruel. 5. Murder was cold, calculated, and premeditated. The trial jury found only 1 mitigating factor. Aileen Wuornos suffered from borderline personality disorder. The jury decided that despite her psychological difficulties, Wuornos knew the difference between right and wrong. The judge found the following non-statutory mitigators. 1. Wuornos suffered antisocial and borderline personality disorders. 2. She may have been physically abused as a child. 3. Her natural father and grandfather committed suicide. 4. Her grandmother died an alcoholic. And 5. Her mother abandoned her as an infant. Judge Blount followed the jury's recommendation of death and sentenced Wuornos to the electric chair on January 31st, 1992. Wuornos did not stand trial again. A bizarre sideshow to the pending murder trial began in late January 1991 with the appearance of Arlene Praley as Eileen's chief advocate. A 44-year-old rancher's wife and born-again Christian, Praley ran a horse breeding and boarding facility near Ocala. She had seen Wuornos' picture in a newspaper and wrote her a letter. "My name is Aileen Praley," she began. "I'm born again. You're going to think I'm crazy, but Jesus told me to write to you." She provided her home telephone number and on January the 30th, Wuornos called her collect for the first time. Soon, they were having daily telephone conversations. Praley became her ardent defender and helpmate. Praley advised her that her public defenders were trying to profit from her story, as was everyone else. Wuornos asked for and got new attorneys. Praley spoke with reporters, describing her relationship with Wuornos as a soul binding. "We're like Jonathan and David in the Bible. It's as though part of me is trapped in jail with her. We always know what the other is feeling and thinking." To another reporter, she said, "If the world could know the real Eileen Wuornos, there's not a jury that would convict her. I just wish I was Houdini. I would get her out of there. If there was a way, I would do it, and we could go and be vagabonds forever." Throughout 1991, Praley appeared on talk shows and in tabloids, talking to anyone who would listen about what she perceived as Wuornos' true good nature. She arranged interviews for Wuornos with reporters she thought would be sympathetic, and in this forum, Wuornos continued to tell her story. Both Wuornos and Praley emphasized Wuornos' troubled upbringing, and both leveled accusations of corruption and complicity at anyone who was handy. And just when it seemed things couldn't get any weirder, on November the 22nd, 1991, Arlene Praley and her husband legally adopted Eileen Wuornos. Praley said God had told her to. What Wuornos did not know at this point, but eventually realized, was that Praley was receiving money for giving interviews, including one with Nick Broomfield, who paid her $10,000. Part of the money went to Wuornos' new lawyer, Stephen Glazer, whom Praley hired. Chief Assistant Public Defender Tricia Jenkins, whose office handled Wuornos' Volusia County trial, accused Glazer of mishandling Wuornos' subsequent cases and appeals. Jenkins testified that Glazer never picked up the discovery files from that case, even as he prepared the case in Marion County. Instead, Glazer filed a notice that he was taking over the case and a motion to change Wuornos' original not guilty plea to no contest on the same day. "He told me he was taking the case because he needed the media exposure," Jenkins said. On March 31st, 1992, Wuornos pleaded no contest to the murders of Charles Richard Humphreys, Troy Eugene Burrus, and David Andrew Spears, saying she wanted to get right with God. In a rambling statement to the court, she said in part, "I wanted to confess to you that Richard Mallory did violently rape me, as I've told you, but these others did not. They only began to start to." In reaction to the judge condemning her again to death row, she hissed, "I hope your wife and children get raped in the ass." On May the 15th, Judge Thomas Sawaya handed her 3 more death sentences. She turned to Assistant State Attorney Rick Ridgway and hissed, "I hope your wife and children get raped in the ass." She made an obscene gesture and muttered, "Motherfucker." The relationship between Wuornos and Praley was not to last. Wuornos began to suspect that Praley was there only for the publicity and the money. Wuornos told Broomfield in an interview that Praley and Glazer were telling her ways to kill herself in prison. She suspected they advised the no contest plea because Glazer was too inexperienced to handle a multiple murder trial. It was around this time that Eileen offered to show police where the corpse of Peter Seams was hidden, near Beaufort, South Carolina. Authorities flew her to the Piedmont state, but nothing was found at the designated site. Daytona police insisting that Wuornos created the ruse to get a free vacation from jail. They speculate that Seams was dumped in a swamp near I-95 north of Jacksonville, but his body has never been found. In June 1992, defeated by the loss of her once trusted friend, Praley, Wuornos pleaded guilty to the murder of Charles Cascadon. The Wuornos case took an ironic twist on November 10, 1992, with reporters' revelations. Detectives had previously denied any evidence existed to corroborate Wuornos' claims of rape or a history of sexual crimes by Mallory. Had detectives searched federal criminal records to check into claims that Mallory was violent, they would have produced this history. However, the judge refused to allow this to be admitted in post-trial proceedings, and Wuornos was never given a retrial. In the official view, Mallory was clean, if somewhat paranoid and sex crazy. Reporters, though, had no apparent difficulty finding out that Mallory had served 10 years for a violent rape in another state, facts easily obtained by checking his name through the FBI's computer network. This information is conflicting because some sources say attempted rape and others say rape. Either way, he had a history of sexual violence. The fascinating part about this is that here is a woman who for the past year has been screaming that she didn't get a fair trial and that everyone was rushing to make a TV movie about her, and in reality, that comes true. In November 1992, she received her 5th death sentence. In February 1993, Wuornos pleaded guilty to the murder of Walter Gino Antonio and was sentenced to death for the 6th and final time. No charges were brought against her for the murder of Peter Abraham Seams, as his body was never found. In all, Wuornos received 6 death sentences. She claimed initially that all 7 men had raped her while she was working as a prostitute, but later recanted the claim of self-defense, citing robbery and a desire to leave no witnesses as the reason for murder. During an interview with filmmaker Nick Broomfield, when Wuornos thought the cameras were off, she told him that it was, in fact, self-defense, but she could not stand being on death row, where she had been for 10 years at that point, and wanted to die. Assessed using the psychopathy checklist, Wuornos scored 32 out of 40, with the cutoff score of 30 for determining psychopathy. The checklist evaluates individuals on a 20-item list of antisocial and interpersonal behaviors, with each item being scored as 0, 1, or 2, with a maximum score of 40. Eileen was housed at Broward Correctional Institution in Pembroke Pines. Side note and kinda fun fact, Broward Jail is now abandoned, permanently shut down in 2012, and is now apparently the creepiest place in Florida. Originally built for men, it ended up being used for women whilst on death row. After the trial, it was revealed that Tyria Moore made several book and movie deals selling her story. So did 3 detectives on the case, who later resigned. The officers maintained that they were moved to sell their version of the case by pure intentions, planning to put the money in a victim's fund. In Florida, the state constitution requires that an automatic direct appeal be taken to the Supreme Court of Florida on behalf of a defendant who has been sentenced to death. The direct appeal cannot be waived by the defendant, and legal representation must be provided to the defendant. Further review may be sought in the Supreme Court of the United States by a procedure called certiorari review. The US Supreme Court has complete discretion to grant or deny certiorari. It need not give any reason for its decision to review or not to review a case. The automatic appeal to the Supreme Court of Florida and any certiorari review of it are collectively called the direct appeal. For the automatic direct appeal, Wuornos was provided a court-appointed attorney, Assistant Public Defender Christopher S. Quarles. On November 16, 1994, the Supreme Court of Florida affirmed Wuornos' conviction and sentence. Wuornos then filed a petition for writ of certiorari in the United States Supreme Court, which was denied on April 17, 1995. During the extensive post-conviction period from 1994 until 2002, Wuornos argued her original trial counsel provided ineffective representation. One example of poor representation revealed in subsequent appeals was trial counsel's failure to uncover Richard Mallory's prior rape conviction, which could have corroborated Wuornos' argument of self-defense. In addition, trial counsel failed to call lay mitigation witnesses during the penalty trial who could have testified to the defendant's claims of abuse during her childhood and adolescence, even though several childhood friends and neighbours said they would have testified if they had been called. In later hearings, several of these potential witnesses testified they were contacted by the media following Wuornos' arrest, but never by the Public Defender's Office. The defendant also argued she had not been effectively evaluated regarding her competency to stand trial. Throughout the post-conviction period, Wuornos' erratic behaviour continued to worsen. She fired several attorneys and in 2001 dropped her appeals completely. Some of these attorneys contacted the Florida Supreme Court to express their concerns that Wuornos was not competent to be executed. Wuornos also wrote several extensive and rambling motions to the courts in which she claimed prison staff were abusing her. All of Wuornos' claims were evaluated and rejected by the state and federal appellate courts. In a 2001 petition to the Florida Supreme Court, she stated her intention to dismiss her legal counsel and terminate all pending appeals. "I killed those men," she wrote, "robbed them as cold as ice, and I'd do it again too. I am so sick of hearing this she's crazy stuff. I've been evaluated so many times. I'm competent, sane, and I'm trying to tell the truth. I'm one who seriously hates human life and would kill again. I wanted to clear all the lies and let the truth come out. I have hate crawling through my system." While her attorneys argued that she was not mentally competent to make such a request, Wuornos insisted that she knew what she was doing, and a court-appointed panel of psychiatrists agreed. Florida Governor Jeb Bush instructed 3 psychiatrists to give Wuornos a 15-minute interview. The test for competency requires the psychiatrists to be convinced that the condemned person understands that she will die and for which crime she is being executed. All 3 judged her mentally fit to be executed. After a hearing in Daytona Beach, the Florida Supreme Court agreed to allow Wuornos to fire her attorneys and stop her appeals. Fort Lauderdale lawyer Rag Singhal wrote a letter to the state Supreme Court expressing grave doubts about Wuornos' mental condition. Executive clemency is the power of an official or agency in the executive branch of government to nullify a criminal conviction by granting a pardon. to reduce a court-ordered punishment by granting a commutation of sentence, or to delay an execution by granting a reprieve. In some states, the governor alone has these powers. In others, the powers are given exclusively to a board of pardons and paroles. In still others, the powers are divided between the governor and the board. In Florida, the governor makes clemency decisions in conjunction with the Executive Clemency Board, on which he sits. The governor has complete discretion to deny clemency at any time, for any reason. To grant clemency, however, the governor needs the approval of at least 2 members of the Clemency Board. On September 30th, 2002, Governor Jeb Bush granted a stay of execution and ordered a mental examination to determine whether Wuornos was competent to be executed. Florida law mandates that an inmate cannot be executed unless she understands both why she has been sentenced to death and that execution results in death. An examination by 3 psychiatrists appointed by the state concluded Wuornos was competent to be executed and the stay was lifted. Before Wuornos' execution, an Ohio group called Florida Support filed a motion on her behalf to stay the execution, citing her extreme mental illness. Florida allows groups or individuals to file such motions on behalf of defendants as next friend in capital post-conviction proceedings. This motion was denied. Speaking from death row, she believes that she is a victim of her life and not a predatory prostitute. Her defense attorney states that Wuornos operates at the emotional level of a 2 to 3-year-old, and her behavior should be understood within that framework. Wuornos' attorney, Rag Singhal, suggested that Wuornos' competency may come into question again if the judge rejects her claims of prison abuse. If the allegations don't have any truth to them, she's clearly delusional, he said. She believes what she's written. Maxine Streeter, Senior Assistant Attorney General, asked Bachman to delay the hearing because Wuornos' 25-page filing was delivered after business hours Thursday. The hearing was called on the basis of a 2-page letter written in January to the clerk of the state Supreme Court. The note ended, P.S. Happy New Year. Wuornos, who calls herself a model prisoner, complained about 8 sergeants and officers assigned to the women's death row unit at the Broward Correctional Institution after she dropped her death appeals. Our guards at Broward who work on the wing where she is being housed have not been exhibiting this type of behavior, and the Department of Corrections will firmly deny any of these allegations, said spokesman Sterling Ivey. Wuornos accused the prison staff of waging psychological and physical warfare against her and wants the 8 officers to be transferred until my ex, her shorthand for execution. She also wants the old staff returned. In a list of 17 complaints, the 11th complaint said, to overhearing conversations in trying to get me so pushed over the brink by them I'd wind up committing suicide before the ex. Singhal said the issue of suicide was a real concern because her father hanged himself in prison and a grandfather committed suicide. Wuornos also reported overhearing staff conversations about wishing to rape me before execution and on the way to Stark in transport or at Stark itself. Death row inmates are executed at Florida State Prison near Stark. She also complained of strip searches being handcuffed so tightly that her wrists bruise any time she leaves her cell, door kicking and frequent window checks by guards, low water pressure, mildew on her mattress, and catcalling in distaste and a pure hatred towards me. Wuornos threatened to boycott showers and food trays when the 8 officers are on duty. In the meantime, my stomach's growling away and I'm taking showers through the cell of my sink, she wrote. Wuornos told Sinkhole that conditions improved after he was appointed. Her attorney stated that Miss Wuornos really just wants to have proper treatment, humane treatment, until the day she's executed. Circuit Judge Paul Bachman set a hearing for August the 19th for a full airing of her allegations. The state promised in court to investigate, but a corrections department spokesman later rejected the allegations. In the weeks before her execution, Wuornos gave a series of interviews to documentarian Nick Broomfield and talked about being taken away to meet God and Jesus and the angels and whatever is beyond the beyond. In her final interview, she once again charged that her mind was tortured at BCI and her head crushed by sonic pressure. Food poisonings and other abuses worsened, she said, each time she complained, with the goal of making her appear insane or to drive her insane. She also turned on her interviewer. "You sabotage my ass, society and the cops and the system. A raped woman got executed and was used for books and movies and shit." Her final on-camera words were, "Thanks a lot, society, for railroading my ass." Broomfield later met Dawn Botkins, a childhood friend of Wuornos's, who told him, "She's sorry, Nick. She didn't give you the finger. She gave the media the finger, and then the attorneys the finger. And she knew if she said much more, it could make a difference on her execution tomorrow, so she just decided not to." Billy Nolas, who represented Wuornos in some trials, said she suffers from borderline personality disorder as a result of neglect and sexual abuse as a child. "She is the most disturbed individual I have represented," said Nolas, who now practices law in Philadelphia. "As she has gotten older and older, she's gotten worse and worse," said Nolas, who believes Wuornos was too mentally ill to comprehend what dropping her appeals and seeking death would mean. "She's like a kid," Nolas said, adding that she pounces and stomps around and doesn't want to deal with difficult situations. Nolas, who refers to Wuornos as Lee, said he believes Mallory raped her and that pushed her over the edge. Information on Mallory's prior history of sexual assault was withheld from defense attorneys. Before that, she had no history of physical violence. Wuornos was transferred to the Florida State Prison for execution by lethal injection, which took place on October the 9th, 2002. She declined her last meal, which could have been anything under $20, and opted for a cup of coffee instead. She was woken up at 5:30, requested a towel and washcloth to wash her face and freshen up. She was very calm and not as talkative as she had been in the past. A half-dozen anti-death penalty demonstrators were outside the prison, but were outnumbered by correction officers. Wuornos was strapped to a gurney and hooked to 2 intravenous lines. 32 witnesses watched as she was wheeled into the death chamber, where an executioner pumped deadly chemicals into her system. Her last words were, "Yes, I would just like to say I'm sailing with the rock and I'll be back, like Independence Day with Jesus, June the 6th, like the movie. Big mothership and all. I'll be back. I'll be back." Wuornos was pronounced dead at 9:47 a.m. EDT, but the process of injecting lethal drugs into both of her arms started promptly at 9:30. A brown curtain was drawn back, and witnesses saw Wuornos turn to them, make a bizarre face, kind of smile, roll her eyes and turn away. She was strapped in completely, unable to move anything but her head. At 9:31, she shut her eyes and her head jerked backward. At 9:32, her mouth seemed to drop open, her eyes opened to slits, and it appeared she was gone. Wuornos was the second woman in Florida and the 10th in the United States to be executed since the 1976 United States Supreme Court decision restoring capital punishment. The first woman was Judy Wuornos, who was electrocuted on March 30th, 1998. Wuornos was known as the Black Widow for poisoning her husband, drowning her handicapped son, and for trying to kill her boyfriend. She was a suspect in the poisoned death of another boyfriend in Colorado, but she wasn't charged. Wuornos was the first woman to be executed in Florida since a freed slave was hanged in 1848. After her death, Wuornos' body was cremated, and her ashes were scattered beneath a tree in her native Michigan by Wuornos' childhood friend, Dawn Botkins. At Wuornos' request, Natalie Merchant's song Carnival from her album Tiger Lily was played at her funeral. Wuornos spent many hours listening to this album on death row. When Merchant found out about this, she gave permission to use the song in the closing credits of Nick Broomfield's documentary, Eileen, Life and Death of a Serial Killer. When director Nick Broomfield sent a working edit of the film, I was so disturbed by the subject matter that I couldn't even watch it. Aileen Wuornos led a torturing life that is beyond my worst nightmares. It wasn't until I was told that Eileen spent many hours listening to my album, Tiger Lily, while on death row, and requested Carnival be played at her funeral that I gave permission for the use of the song. It's very odd to think of the places my music can go once it leaves my hands. If it gave her some solace, I have to be grateful. Broomfield later speculated on Wuornos' motive and state of mind. I think this anger developed inside her, and she was working as a prostitute. I think she had a lot of awful encounters on the roads. And I think this anger just spilled out from inside her and finally exploded into incredible violence. That was her way of surviving. I think Eileen really believed that she had killed in self-defense. I think someone who's deeply psychotic can't really tell the difference between something that is life-threatening and something that is a minor disagreement, that you could say something that she didn't agree with. She would get into a screaming black temper about it, and I think that's what had caused these things to happen. And at the same time, when she wasn't in those extreme moods, there was an incredible humanity to her. Broomfield said, "My conclusion from my last interview with Eileen is today we are executing someone who is mad. Here is someone who has totally lost her mind."